Okay, so that's Detective Juan Guzman testifying about the phone activity from the defendant's phone. Let's bring in my guest to talk about some of that testimony right now. Still with me is federal litigator and trial attorney Alexis Rosenberg. And now joining me for this hour also is criminal defense attorney and host of the Defense Diaries podcast, Bob Moda. So Bob, I want to start with you. What are your thoughts on the defendant calling the alleged hitman, now decedent, Miller, more than 230 times in this particular time period?
I mean, when it's put out there like that, it's a little disconcerting when you break it down to, over the period of 2 months that it's 2.5 calls a day on average. It's not quite as shocking. I actually thought the defense did a very nice job on this cross-examination, wherein they kind of broke it down where they're delineating between text messages, which we all use more frequently. I rarely make phone calls these days. Almost everything is text. And like if I'm texting with, say, my wife, I'm like a one sentence per text person. So if you were to look at my text messaging throughout the course of a day, like say, again, to my wife, I probably text her 300 times in a day, which would constitute maybe one long phone conversation. You know what I mean? So I think that the defense was able to do a pretty nice job with kind of like offsetting the number of calls over that period of time. So we'll see how it plays out, but I'm actually giving the points to the defense on this one.
Yeah, Alexis, I want to get your take on the same question, right? So you have this quantity of communication between the defendant and then Miller. And then the defense is sort of able to take that back. But you heard the redirect. The portion at the end of the clip we just saw was the redirect by the prosecution. The prosecution made a point, like, how many times are you going to communicate with your handyman? Do you think the prosecution was able to get back some of those points and rehabilitate some of the testimony?
I do. Listen, almost 3 calls a day. I don't even think I call my own husband 3 times a day, and not even in 2008. Why is he calling his handyman that much? That's ridiculous. The prosecution was really good to break it down. We've got the mistress, the wife, I love the lineup, and then his handyman as most of the calls. This is a lot of calls. I mean, this is a lot of calls that we have going on, unless they were actually having some sort of relationship too, which it appears that they were in sorts having, or, conspiring to have her murdered, because that doesn't make any sense. Was the whole house on fire? Was it falling down? I mean, why would you need to speak to your handyman that many times a day?
Right. And Bob, I want to get your opinion now here. So you have the defense theory of the case, that this was sort of self-defense or defense of another, why Miller was shot by the defendant. Of course, the prosecution saying that this was a alleged hitman and that the defendant decided to take him out also. Does the defense theory get harmed by the level of communication between the defendant and Miller?
I mean, if you're going with the state's theory in the case, then yeah, they're calling him a handyman for a reason. If it's what happens if he's his friend? Like, if legitimately they're friends at this point, does it seem quite as strange when you're talking about, a handyman? Why would he ever be calling a handyman so many times in a day? What happens if the guy's his friend? So, it was a brilliant move by the state to kind of put him into the category of a handyman as opposed to a friend, because it changes the dynamic, doesn't it? Like, quite a bit. I'll call my friends intermittently throughout the day, and it doesn't seem as shocking if the jury is left believing that this guy was merely a handyman and there was no relationship beyond that. Then yeah, it's extremely powerful evidence, because it goes to, as my co-guest said, why in the world would you be calling your handyman twice a day for 2 months straight, other than it would seem to be nefarious reasons.
Yeah, no, absolutely. And let's take a look at some more testimony that occurred yesterday in court. And this is crime scene analyst Jeff Smith. He took the stand yesterday. Let's take a listen as to what he had to say. Okay, so that's testimony from CSI telling about the investigation at the crime scene, some of the findings that he saw. Let's bring in Alexis Rosenberg, who is a trial attorney down in Florida, and also with me, criminal defense attorney and podcaster Bob Mata. Bob, I want to talk to you about what we heard about the door. There was no signs of forced entry, and of course the defense theory of the case is that this was a home invasion, this was an intruder, and that the shootings were done, at least of Miller, in self-defense or defense of another by the defendant. The fact that there's no signs of forced entry, do you think that's going to put some question as to that defense theory in the jury's mind?
Yeah, well, I think it's going to depend on whether or not the defense is able to get in any kind of information. I don't know what the Randolphs' habit was in terms of leaving their door open. For instance, I live out kind of like west of the city of Chicago by about 45 miles. Probably shouldn't broadcast this on live TV, but we have a tendency not to lock our front door just because we live in a pretty safe area. It's probably a bad habit, but I don't know what his habit is. If they don't leave their front door open, or if they lock it every day and it's always locked, if they can get some testimony on there in terms of the state that that's their habit, then that becomes extremely powerful because it insinuates the fact that this guy had carte blanche to get in the house. And then you couple that with the fact that it appears that the padlock on the gate on the outside was removed and that Miller had an idea of where the key was at in order to access that and be able to unlock it, which means he just had unfettered access to the house, which is extremely damning in terms of the defense's case.
Absolutely. And also, Alexis, I want to get your thoughts on the other piece of testimony that we heard here was that the house didn't appear to be disheveled or disorganized in any way. Same question. You think that's going to be a piece of testimony that the prosecution is going to be able to use to poke holes in the defense theory of case, that this was an intruder?
Definitely. I mean, if that was the case, we would have had, some sort of scuffle, or there could have been something. And the fact that the crock pot and everything was still up there is very interesting because there would have been some struggle or there wasn't, as the prosecution wants us or to believe, that he just went in there and basically shot him and didn't realize it was coming.
Absolutely. Great points from both of you. And we're going to take a quick break here at Law and Crime. But stay with us. When we come back, more from the retrial of defendant Thomas Randolph on the other side. Welcome back to Law and Crime. I'm Imran Ansari. We're covering the Thomas Randolph retrial in Nevada, and we just saw before the break a walkthrough that Thomas Randolph did within his residence, the crime scene, with law enforcement. That was videotaped, and I want to chat with my guests about what we saw. I'm joined by federal litigator and trial attorney Alexis Rosenberg, along with criminal defense attorney and host of the Defense Diaries podcast, Bob Mata. Alexis, I want to start with you. Let's think about the video we just saw and also compare that with the testimony we heard from the crime scene analyst Jeff Smith earlier on in the program. First, what do you think about the defendant's demeanor during this walkthrough, and does it really comport with what we heard from the analyst Jeff Smith, at least as to his description of the crime scene?
No, there are definitely some inconsistencies, and his demeanor is questionable. Now, people do process trauma in a different way, but the fact that he was so matter of fact and very detail-oriented and emotionless does cause some concerns. I think the jury is going to not see that as beneficial for his case. I mean, one thing that really stuck out to me was when he was on the ground and he was basically reenacting how he found his wife, and he used the word gross. I mean, that's not really, if you find your wife in that condition, that would be the first word to describe the situation. And he's more concerned when he goes into the reenactment about the gun. She's basically either dead or dying in front of him at that point, and he's concerned about this gun.
Absolutely. And Bob, same question. What do you think about his demeanor during this walkthrough? He's lost his wife. He's shot someone in his residence. And of course, we know the history of Thomas Randolph. The problem with the first trial was that the jury got to know a little about the history of Thomas Randolph, and that was deemed to be too prejudicial, and that conviction was thrown out. But what do you think about his demeanor during this walkthrough, and how do you think that this jury would be seeing this videotape in light of the charges he's facing and the other evidence that they're going to receive from the prosecution?
I mean, the simple answer is he seems like a sociopath. It's like my father defended John Wayne Gacy, and he gave me all these tapes, and I would listen to these tapes, and he would talk about killing people as if he was talking about taking out the trash. It was so disconcerting. It was far his tone and tenor was more unnerving to me than what he was describing, just because he was so matter of fact about it. And he has the same type of demeanor going on, because we're talking presumably days after his wife is murdered. Now, obviously there's information out there in terms of evidence that he was in some type of relationship with another woman. We know that he was making hundreds of phone calls to this other woman as well. So, I mean, that may play off in the jury's minds. Whether that makes him sympathetic at all, I doubt it. You're compounding the fact that not only has his wife been killed, but now they're led to find out that he was probably more likely than not having an affair. So I think that's all going to play against him. But really what it boils down to, as a criminal defense attorney, this video is like my worst nightmare. Like the first thing I ask my clients when they come in deciding whether or not they're going to retain us is like, did you make a statement? In terms of if they've had police contact. This guy not only made a statement when they had him down at the station in terms of that interview that they did, where the cops were pretty even-handed with him. I mean, they weren't coming at him hard at all during that, because I think that was more of a fact-finding mission at that point for them. I don't know if they had gotten the leads report on this guy. I don't know if they knew his background, at least in the beginning of that interview. But then he goes on to do this entire reenactment thing. And this is going to be the gift that keeps on giving to the state, because what they're going to be able to do is pinpoint every single inconsistency from what he says in that video to what they were able to actually to recover and process when they processed the scene. It's going to be, I think it's going to end up being his downfall, to be honest with you.
Yeah, Bob, you make an excellent point. I was going to raise that, is that, of course, the defendant there's no necessity whatsoever. It's a constitutional right, of course, for the defendant not to have to put on a defense or give testimony at a criminal trial like this. But here you have a protracted video where he's walking law enforcement through, and it's really something which you could compare, and we can do so even with the testimony of the crime scene analyst that we saw, and pick out those inconsistencies. Another question to you, Bob. As a criminal defense attorney, what are you going to do to sort of mitigate the effect of this video for your client? What are some of the techniques or game plan, if you will, that you would implement in order to sort of downplay this video for the jury?
In terms of the video itself, clearly when they're putting it on through a witness. So, they're not going to be able to do much in terms of mitigating it through that witness, because it's obviously not Randolph testifying. One way to do it is obviously, it's yet to be determined whether or not he's going to testify in this trial. I have a feeling that that's going to be a game time decision after the state's case in chief is done, and whether or not they feel like it's going to become a necessity and they're going to say, hey, we think that you should testify. Ultimately, it's, of course, the defendant's decision. But, in terms of kind of the story, I think that what they're going to try to couch it in terms of, in closing argument, say, look, this guy had nothing to hide. This was a situation where he walked into it. He's been completely candid and open the entire time with law enforcement. There was no lawyering up. There was no clamming up. Not only did he make a statement and not seek to have counsel with them at that point, he then went even further than that, because he wanted the truth to be known, and he brought the police on a walkthrough of exactly what happened. So they're going to have to play it like that. Depending on when the state is able to just pinpoint the inconsistencies with what he said happened and with what the crime techs ended up discovering when they processed the scene, that's going to ultimately be the big question. If his reenactment turns out to be pretty spot on, if he's that bright of a guy to where he was able to, really capture everything that he was going to be telling law enforcement in a way that was going to exactly mimic what went down in that house that night, kudos to him, but the likelihood of that is slim and none.
Yeah, great points, Alexis and Bob. And we're going to take a quick break here at Law and Crime. But stay tuned, because when we come back, more from the Thomas Randolph retrial in Nevada. Stay tuned. Welcome back to Law and Crime. I'm Imran Ansari, and we're covering the Thomas Randolph retrial in Nevada. And we just saw that walkthrough with the defendant and law enforcement through the residence, through the crime scene. I'm talking to our two great guests about that. Still with me is trial attorney Alexis Rosenberg, along with criminal defense attorney Bob Mata. Alexis, I want to talk about this trial in general. It's a retrial, and we've been looking at the testimony coming before a jury for the second time around. There was a conviction in the first trial. Of course, that trial was overturned, thrown out, because some of the prior bad acts of this defendant came before that jury that was deemed to be improper, more prejudicial rather than probative. So what do you think we're going to see in this trial? Of course, the prosecution putting on much of the same evidence before that they already had in the first trial. So this is a second time around. Do you think that the prosecution will be able to secure a conviction despite sort of that prior bad act evidence being excluded?
Well, I mean, that's ultimately the question. I mean, we are not going to see the testimony about prior bad acts, obviously, because I don't think they want to try this again. So we have that. But, I mean, there is a lot of evidence other than that. I mean, yes, that video we just saw is damning, because we have a situation where they can pick apart that and put on expert testimony and other law enforcement to pick apart what he's saying, that's not how it happened. I also think that we're not going to see him testify. I mean, to allow them, the prosecution, to be able to cross him, I think will be very damning. The fact is, we have this video, so the defense in a certain circumstance already has him being able to testify without being crossed. So I don't think that we're going to see that. But I think the rest of the evidence that the Nevada Supreme Court found that really should not have been admitted, I think they're going to continue to put that on at this trial as well.
And Bob, we hear from our correspondent, Melissa McCarty, who has been inside the courtroom for Law and Crime, that Michael Miller's family could be testifying today. I want to get your thoughts on that. As a defense attorney, how do you cross-examine a member of a victim's family if they take the stand for the prosecution? What sort of considerations do you have in mind?
Very carefully, and depending on how. It's difficult, though, because you've got two competing theories here, right? You've got the theory that he wasn't just a handyman, but that he was a burglar, that he was coming in and that he shot this woman. So as a defense attorney, you always want to handle victims and their families extremely carefully and gently on the stand. You don't want to come off as a bully in terms of your questioning, because it's gonna turn the jury off completely and probably have them hating you, which then gets transferred onto your client. So you have to go about it very carefully. But this is a different type of situation, because there's this theory that by the defense that this guy was a bad guy. You know what I'm saying? So it's like, that's a tricky one, to be honest with you. I think I would have to wait and see how the direct was going to go and see what direction they were taking it, and then I would carefully pick and choose my questions, trying to get some more background about Miller in order to try to flesh out our theory that maybe this was somebody that was more than just a handyman. Maybe there was a friendship between these two that was blossoming. And just try to kind of like fill out the picture a little bit, because right now Miller's really the X factor. We just don't know much about him, other than the state keeps calling him a handyman. I don't know anything about the guy. You know what I mean? So I would be taking that opportunity to really try to get the jury to know more about this guy, if it's beneficial to the defense.
Yeah, and let's talk about the defense, Alexis. Your client's been convicted the first time around, and the prosecution was able to convince 12 jurors to convict. What are you doing in this case that you may have not done on the first time around?
Well, I mean, the good thing is, when you have that opportunity, is the fact that you can go through and try and correct, like what you just mentioned, the things that you thought were weak points. I think that they need to downplay his relationship with the mistress as the best that he can, the best that they can. I think that they need to strengthen that they had a healthy relationship, as well as they need to focus on, as much as they can, the defense, and they need to focus on, what just was said, that this relationship was a friendship opposed to him being a handyman, and downplay the hired hitman aspect of it.
All right. Alexis Rosenberg, thank you for joining me here at Law and Crime. Bob, you're going to stick with me. We're going to take a quick break here at Law and Crime. Stay tuned. More of Randolph when we come back.